see here. Hi, I'm Rachel Porter. I know most of you, class of '06 at Wells, and I work in the Alumni and Alumni Engagement Office with Pam and Michelle and Larry and Una, who are all on tonight. Excited to be here. This is our last Learning by the Lake of the school year, and we'll continue again in September. But I do want to give a little plug for the Wells College and the Women's Movement in-person Learning by the Lake, which is June 5th through 7th. And you can check out the details at alumni.wells.edu if you're interested. It's going to happen right after a reunion. And it's a 2-day in-person post-reunion program that will explore Wells College in the context of the women's movement of upstate New York, and will consist of focused presentations, discussions, and field trips. And actually, one of the speakers on tonight, Fran Kissel, is class of '78, is one of the presenters there. So check that out. And as always, if you're, this is a free program, but if you're able to ever make a donation to Wells, we really appreciate, so we can continue this programming at wells.edu/ I just lost the website in my head, I'm sorry, /giving, is it /giving? Pam, okay, yeah, wells.edu/giving. It's much appreciated. So I'm going to give up the Kyugo land acknowledgement, which was approved by the faculty in 2018. Wells College recognizes our collective responsibility to acknowledge our colonial history. This land is the traditional land of the Kyugo Nation, a member of the Haudenosaunee Confederacy. Wells College commits itself to ensuring the traditions and culture of Indigenous peoples are embraced and reflected upon in order to engage in solidarity with the Kyugo Nation. So Brad Murray, a proud 2015 graduate of Wells College. He majored in sociology and anthropology before attending Albany Law School. He graduated from Albany Law in 2018. He is currently an associate attorney with the law firm of Cioffi, Slezak, Wildgrube P.C. Oh, pronounced, sorry, Cioffi, Slezak, Wildgrube in Schenectady, New York, where he practices in the areas of estate planning, trust and estate administration, elder law, guardianships, and real estate law. He serves on the executive committee of the New York State Bar Association's Trust and Estates section, and he's a member of the Schenectady County Bar Association and the Estate Planning Council of Eastern New York. Brad is also a board member of the Wells College Association of Alumni and Alumni and serves on the Wells College Planned Giving Committee. He resides in Schenectady with his partner, Leslie Green, 2017, and their 2 pets. And then I also want to give a legal disclaimer about how Brad is only licensed to practice law in New York State, and that nothing discussed during the course of this presentation is intended to be legal advice. But I'm really excited. We're going to just get some great stuff from Brad, and you can see this presentation on the Wells College YouTube page afterwards. And I'm going to hand it off to Brad. If you have questions throughout, we'll keep an eye on the chat section, or later he'll have a Q&A session, and you can ask questions by unmuting yourself then, or put a question in the chat. And then if you think of anything afterwards, feel free to send us an email at alumoffice@wells.edu, and we can connect you with Brad. All right, take it away.
Thanks, Rachel. Okay, I'm going to try to share my screen. So I tested this once before, although Rachel, can I? Oh, I just have to click the button. Huh. There we go. Okay. Can you all see this?
Yes.
Okay.
Looks good.
Just the slide. Perfect. All right. Hi, folks. Thanks for joining. It's so nice to see so many faces that I've seen before and some new names. Hopefully you find this useful. Like I said, it's not really geared to any specific state. So it's just a standard overview of the basic pillars of a good plan for your life, essentially. So we'll get started. Here's my basic information. Please don't, I mean, if you want to, you can call me by my full name. No one ever does. So, but feel free, this will show at the end too. If you have any concerns that you don't feel comfortable asking during this talk tonight, feel free to shoot me an email, give me a phone call afterwards, and we can chat. Let's see. There's just a photo of all the attorneys in the firm. This isn't actually the most updated photo. We've had one person leave, but we've added 2 new faces. So stay tuned for an updated photo. I am the only man, in case someone was wondering. This was for the longest time an all-female law firm. They now have to say they're an all-female owned law firm. And then hopefully one day when I become partner, it will be a mostly female owned law firm. But the largest law firm in our county, the largest, I believe one of the largest female owned firms in the state, very deep roots to this area. I'm very fortunate to work with many talented, powerful, smart women. I learn so much from them each day. And I'm very fortunate to be where I am. So I thank all of them, because I wouldn't be where I am today without their help, support, guidance, insight, all of that. We'll just keep moving. So before I sit down with people to talk about setting up an estate plan for them, we send out a data worksheet to just gauge some basic info, which includes this type of information that you see on the slide. So we ask about, what are your assets? Do you own a house? Do you have bank accounts? If so, how are they titled? Are they joint with anyone? Is someone named on the account to inherit it after your death? All of those types of things. Do you have an IRA account, a 401k, a 403b? Given where we're located, there's a lot of state workers. Do you have pension? Are you expecting to have a pension, after you're done working? Do you currently have a pension? Do you receive any, are there any payments from those benefits after your death? If so, who's scheduled or who's listed to inherit those? All of those types of things. And then we also ask about income, salary, any other monthly income payments, any RMDs from any IRA accounts, those types of things. It can be an uncomfortable thing to talk about sometimes. I've met with people before who will say, well, I don't really know this. I haven't looked at this information since I set up my 401k when I was 25 years old or something like that. And I kind of scream in my head and say, oh my God, like let's take a look at some of that. It can also be uncomfortable just because oftentimes this is information that people don't like sharing, and especially with someone who they might just be meeting for the first time, me. And my answer to that is always, I cannot do my job and give you the best, to just really tell you what you should be doing, give you the best advice, that's the word I was looking for, possible, unless I receive all this info. And sometimes I'll still have people that won't share it all with me, but if you're ever sitting down to do your own planning with, either with a financial planner or a lawyer, be prepared to give out this kind of info, and just know that it's normal, because they're working within your, they're working for you, and they want to do the best job possible. So that's why this info is so important. With that said, let's jump into the estate planning basics. So the 3 pillars, as I like to call them, is a healthcare proxy and a living will, usually combined, a power of attorney, and then a will. Those are the 3 basic pillars of estate planning that every single person who's over 18 years of age should have. With that said, if you don't have one, it's okay. But you should have one, and I hope that my talk tonight will help bring that point home. So the first pillar that we'll focus on is the healthcare proxy and living will. And again, it's our form that we use it's just one form for both of those things. We'll start with a healthcare proxy itself. Pretty simple. You may have filled one out with your doctor, with a hospital, something like that. It basically allows you to name someone to make healthcare choices for you in the event you're unable to make them for yourself. And so in the event, you're in a car accident, and you can't speak, you can't verbally speak with the EMTs or the doctors at the hospital, they'll call your healthcare proxy and say, oh my gosh, you know, Bill just got into an awful car accident. Like, what do we do? You know, what like, help us, like, you know, is he on any medicine? All those types of things. The second part, the living will, really relates to when you're in a permanent vegetative state, meaning that the doctors have certified you're still alive, but you know, you're not going to recover from whatever condition you're in. It's not necessarily that you're in a coma, but you're really being kept alive, being hooked up to some pump or something like that. And without being hooked up to what you're currently on, you would essentially pass away. In those instances, you can choose whatever language you want. Our standard template language says that you don't want to be kept alive on life-sustaining measures, but you want maximum pain medicine so that when you do pass, you know, it will be painless. You won't feel anything. But we've had people change that and say, no, I do want a feeding tube. You know, I do want these things. It can be totally changed to whatever you're comfortable with. But again, it really applies to when you're in that permanent vegetative state. It is not a DNR. It is not that. It doesn't mean if I have a heart attack or something like that, they're not going to help me, right? It's just in the event that you're in that permanent state, you know, chances of coming out of it, chances of, you know, regaining any sort of normal bodily function is slim to none. And it has to be certified. That has to be certified by 2 doctors, not just one. That's the healthcare proxy in a nutshell. I'm going to move on now to the power of attorney. Oh, and here's a fun little cartoon. The husband says, I don't want to live in, you know, a state where I'm hooked up to some machine. And the wife says, okay. And then she unplugs the TV that he's watching. We're not that funny here, but sometimes it's fun. So the next document is going to be the power of attorney. So whereas the healthcare proxy deals with the healthcare side of it, right, making medical choices, the power of attorney basically deals with all other aspects. Most people think about it as your finances, you know, it gives someone the ability to write checks, pay bills, those kinds of things, yes, but it also gives them a wide range of other powers. They can start a lawsuit on your behalf. They can sell a house on your behalf. They can do any, they can handle any business entities that you might own. They can handle all of that, you know, wide range of powers. Essentially, you can give your agent the ability to step into your shoes. Anything that you can do, they can do. It is not effective until both you and the person you're naming as your agent sign it. So for example, I have one naming my partner who I've been with for 8 years, but she doesn't need to act for me right now. So she knows, God forbid, if something happens to me, she knows where I work, obviously, but so she would come to the firm and say, oh my gosh, like, you know, he hurt his arm or something, I can't sign checks or something like that. And then she could sign at that point to be able to act for me. That's one check that we do have. Whereas if someone wants to have this type of planning in place, but they're not comfortable having the person act right now, you know, that is an option. With that said, my slide notes that there were some major law changes in 2009, 2010, and a smaller one in 2021. Again, that's just for this state. It's not for all states. All states usually have their own template form. Some of them you can find online through a bar website or something like that. Others you might have to make a call to a law office. But I always recommend using, and I am a little biased, but I always recommend using a lawyer, because these forms, while they might seem, you know, pretty basic, there are some things where if you don't initial in the right place, but also sign a separate form, you know, putting those powers into place, it might not be fully effective. It might not give you all the power that you want. So always a good idea to have someone that works in this field take a look at it, even if you've already done it yourself, just to make sure you have everything that you actually want to. And the important thing to know, if you've done an old power of attorney and then the law has changed, you're still okay with your old one for the most part. With that said, always a good idea to update them if people have moved, if names have changed, all those types of things. We usually recommend taking a look at both the healthcare proxy and the POA every 3 to 4 years. Make sure the people that you're naming are still who you want to name as your agents or co-agents or backup agents, and make sure that no one's moved, names haven't changed. If any of that's happened, it's usually a good idea to update them at that point. And I mentioned it briefly, but I'll hit on this more now. You have the option to name co-agents if you want, so you can name multiple people just on the POA though, not on the healthcare proxy. Healthcare proxy, it can only be one person at a time. But on the POA, you can name co-agents to act at the same time, and you can choose whether they act as a unit or whether they can act separately, meaning do they both have to go to the bank to withdraw money? Do they both have to sign checks, or can one of them do it on their own? You can also name on both the healthcare proxy and POA as many backups as you want. So for example, if you want to name your spouse and then maybe your child and then maybe one of your other kids as a further backup, all perfectly fine. All can be done.
Sorry. When do the backup people become effective? Because I know you said that the POA isn't effective until you and the other person sign it. But what if something happens to both of you at the same time? Like, when does the third choice become effective?
Right. No, that's a great point. So you would have to essentially prove that either the original agent named is no longer able to act, such as they've passed away or they're in a nursing home, they're suffering some sort of issue, either in some sort of health issue. I won't dive into certain things, or they can choose to step down. There's a template form that we have that they could fill out saying, I'm no longer willing to act. And then at that point, it passes to the backup agent. And we never have backup agents sign unless the original agent can't act. So, because that way banks don't get confused. Why did both the original agent and the backup agent sign? Just because it just makes it simpler.
Thank you.
Yeah, of course. The other thing I'll mention for both the healthcare proxy and power of attorney is that they end at death. As soon as you die, they're no longer valid and your will takes over, which I guess is a good segue for us here. So the last item that I'll speak about in terms of our 3 basic pillars is the last will and testament. So I guess we'll back up for a second and say, how do your assets pass on death? Well, obviously we say, by law. So for example, a lot of you might own a house as joint tenants with rights of survivorship with your spouse. Your will doesn't control that house. Your will could say, I give that house to my best friend. But if your deed says joint tenants, it's going to be owned by that joint tenant upon your death. So it will not pass through your will. Same thing by contract. We're talking about, if you have any sort of business entity like an LLC, or if there's a prenup that you might have signed, that will take effect at that point. Or per the terms of your last will and testament, if you have one. And if you don't, that means you died intestate, meaning without a will, and you'll pass pursuant to the intestacy laws of your state. So let's start, again, basics of a will. We usually have a family statement, just basically saying, this is me, I live in this county, within this state. We'll talk about whether you're married or not, or whether you have a partner or other person in your life. We'll discuss any children you might have, and we'll also discuss who your closest living heirs at law would be. So usually, if you have a spouse or children, those are considered your heirs at law. But if you don't have anyone, we got to sometimes look to, first cousins, aunts, uncles. So we always like to establish that usually in our wills, just so it's very clear when you die who we're going to have to be in touch with in terms of filing some sort of court action to have your will admitted to the court. After that family statement, you can really do whatever you want in your will. Like I said, you can make a specific gift of your house as long as it's actually going to be part of your probate estate upon your death, meaning it's in your name alone, because your will only cover assets that are in your name alone upon death. So all those accounts that we talked about at the very start, if you've got people named on them to inherit them, or if you've got joint bank accounts, or if you've got, accounts that are payable on death to someone, none of that is controlled by your will, because your will only controls assets that are in your name alone at death. Other language that we usually include in our wills includes a gift of your tangible personal items. That would be stuff in your house, furniture, books, pets, unfortunately, are considered tangible personal items, although it's easier that way. But I always think of my dog as more than just a personal item. She's my baby. But with that said, so you can gift that any way you choose under your will. Again, the most common setup that I see, especially if I'm meeting with two spouses, is all to my spouse if my spouse predeceases me to my kids. That's the fairly straightforward. With that said, families are always changing. There's stepchildren, half children. So people do tons of things. So there's no one right or wrong way to set up your will. With that said, after the tangible personal items, you can make any specific gifts you want. If you want to make a $50,000 gift to Wells College, they did not put me up to that, and you certainly don't have to, but you could do that in your will if you wanted to, or make a gift to any other entity or not-for-profit of your choice, something like that, or make a gift to your friend, or make a specific gift of cash, a specific amount to anybody that you choose. After that, usually what comes is what's called the rest, residue, and remainder of your estate, or as I like to call it, the RR and R, because it's easy. So this is everything else that's going to be in your probate estate after any specific gifts have been made. Those will all pass pursuant to your rest, residue, pursuant to that section of the will. Again, the most common setup that I see is all to my spouse if my spouse predeceases to my children per stirpes. And that's an important thing to note. Per stirpes, you have the option to use that language, which means if someone that's inheriting under your will has passed away before you, per stirpes means that their share carries on to their children. Some people like to use that, some people don't. It's whatever you're comfortable with. Again, there's no right or wrong way to do that. After your will essentially gives away all of your assets, there's a section where you can name the fiduciary for your estate. So the person that will be in charge of probating your will with the court, that will be in charge of making sure that all your assets are marshaled and then paying out the assets pursuant to the terms of your will. And you can name co-fiduciaries if you want. You can name one, you can name multiple, you can name as many backups as you would like. With that said, I always caution people, it's sometimes not a good idea to have a lot of cooks in the same kitchen. And so I sometimes will caution, because some people will say, well, I have 3 kids and I want them all to act. And I'm like, oh geez. So usually if you can, I always recommend just appointing one person with one backup or multiple backups, in an order that you're comfortable with. When you start getting to naming 3 or 4 people to act all at once, that can just lead to some testy things. If one person doesn't like, how you split up all the personal items or something like that, it can just lead to a lot of issues. Better to have 1 point person or a couple point people as opposed to 4 or 5. But that's just my personal view. Again, there's no right or wrong way. There's only best ideas. So we can't force you to certainly do anything. So it's whatever you're most comfortable with. I think I'm hitting all the points that I wanted to in the will. I'm trying to think if there's anything else that people usually ask about or that people are concerned about. I guess I'll also mention, once you pass away, your fiduciary under your will, it has to certainly pay any debts that you owe at your death. Unfortunately, most debts are not do not vanish on death. So if you owe taxes, if you owe bills from a hospital or something like that, all of those still have to be paid. So they all of that gets paid first before anything else is paid out of your assets. And then any taxes that are due. I know I mentioned taxes as part of debts, but here we're talking about any estate taxes that are owed. Usually there's not an estate tax problem. I'll get to that more in a minute. But if there is any estate tax owed, that will also have to be paid before any money's paid out pursuant to the terms of your will. Now, I'll switch gears now and talk about what happens if you currently don't have a will and you were to pass away. So as I said, there's laws that will come into place at that point to essentially take over and say, okay, you died, you don't have a will, here's what happens. Most people assume that, if they have a spouse and they die and they don't have a will, everything goes to their spouse without any issues. Unfortunately, that's not the case. At least in this state. Again, every state has different laws, but if you died intestate here in this state, so if you have a spouse, the first $50,000 goes to the spouse, and then everything else that's in your estate, again, assets in your name alone, is split 50% to the spouse, 50% to your kids, if you have any kids. And if you don't have a spouse and kids, it goes to your parents. If your parents have passed away, it goes to your siblings, and then out from there to aunts, uncles, first cousins, so on and so forth. So this becomes an issue. And the most common issue that I see is when someone young passes away and they have a spouse and minor kids, kids who are under 18 years of age. Now there's a separate court proceeding that we have to go through. A special court attorney is appointed to act within the best interest of the minor, because now they're about to come into some money and they can't legally hold it or accept it. Just various issues there. So that's why it's always better to have a will if possible, because the will can take care of those types of things. If someone were to pass away and money would be inherited by a minor, there's language you can put in there, having that money held back until the minor reaches a certain age, or paying that money over to the minor's other living parent, if possible, or something like that. So that's, again, wills are just a lot better. But if you don't have one, there are default laws that come into place at that time. With that said, you might have money passing to someone that you don't want it to pass to. I'm working on a case right now where the husband did not have a will and he passed away, and his wife, and the house was just in his name. Well, wife wants to keep living there, but there's a stepdaughter from a first marriage that, wants her share of the estate, which includes a certain value of the house. So now the wife has to buy out the stepdaughter's interest in the house. And you can avoid all that by either having the house joint with your spouse or having a will where you give everything to your spouse, if you were to pass away. So that's just one example of how it can get pretty messy pretty fast. And the messier it is, unfortunately, the more money it's going to cost to hire a law firm to sort all that out. So it can all be avoided by either having, assets that pass outside of your probate estate, joint assets, joint bank accounts, those types of things, or having a will to control what happens after your death. I believe that is all I had for the basic pillars of estate planning. I can dive into more complex estate planning, but I hesitate to do so just because that becomes more state specific. And I know we've got people on from various parts of the country, so I hesitate to do that. So I'll open it up to any concerns, or if anybody wants to ask anything. And then if there's still a good chunk of time left over, I might dive into some other things, but I'll open it up. Please shout out, ask anything.
Hey, Brad, it's Randy.
Yes.
Thank you for a very helpful and informative session. I have a question,
course.
maybe to kick it off. Let's say somebody has a relatively simple situation. They have a will and they pass away. And many of our parents, for example, might be in apartments or nursing homes or whatever, so they don't have real estate. And perhaps all of their intangible assets, whatever mutual funds, have payable on death, instructions. So everything is really simple. They have just a few possessions. Do you need, what's the role of, do you need a lawyer to help settle the estate in simple cases like that, or in all cases, would you recommend it? What's the role of the lawyer upon death, even in the case of simple situations?
Totally. So it depends on how simple we're talking. Are we talking some minor bank accounts, or are we talking really just personal items in the home? I can only speak again to the state where I live and work. But there is an option, what's called a small estate, which is a separate court process that you can do. It's fairly user-friendly, and a lot of people actually do it on their own. It covers up to $50,000 in, stuff in the estate. So if you have a couple bank accounts, maybe, a few $1,000s here, a few $1,000s there. That's a relatively simple process that most people can handle on their own without having to hire a lawyer or something like that. But I would say anything above that, you usually want to get someone involved just to make sure you're filling out the right paperwork, you're abiding by the terms of a will, or if there's no will, you're abiding by the terms of the state that you live in terms of what happens to the assets upon your death. But yeah, so there are options for the more simple things where most money's passing outside of the estate, like from accounts that have, people named on them to inherit them, or accounts that were joint with someone, for sure.
Okay, and then maybe the follow-up is, let's say you have a more complicated case where there are assets, real estate, whatever. What's the role of, would you recommend having a lawyer then? I assume you would. And then what's the role?
Always.
What does
Always.
the lawyer do?
Yep. So similar to when I'm meeting with someone to talk about, setting up a will, setting up healthcare proxy power of attorney, we have a separate worksheet that we'll send to someone, when one of their family members or some other loved one has passed away, just to collect basic information about the person who died. Did they have a will? If so, who's named in it, all that type of info. We'll ask about assets, what we expect to be in the estate, what's going to pass outside of the estate, so on and so forth. From there, after we have a good handle on it, we complete the paperwork that has to be filed with the court. We have a software system that pulls it all, so it's relatively simple for us to do that. The forms that are available at most courts, at least in this state, for public use without an attorney, are not very good, and they're not easy to walk yourself through. We'll just say that they're not user friendly. And so that's kind of our role at first, is to at least, walk everyone through that paperwork. Here's what happens. But then once someone's appointed as the fiduciary for the estate, then our role is to really step in and advise them as to, okay, let's close out these bank accounts, open a checking account in the name of the estate, start paying these debts. And then we also inform them of certain timelines that the courts have in terms of filing a list of the assets. You have to wait a certain time period for anyone that's owed money from the estate, such as like any unpaid bills, all those types of things. They have 7 months, again, in this state, to file a claim against the estate. So it can snowball from there. With that said, Randy, there's also some people that will just hire our firm or a firm to get them to fill out all the court paperwork to get appointed as the fiduciary for the estate. And then from there, they're like, I've got it. And we send, a typical letter notifying them of all the deadlines that they have to meet, all that types of stuff to cover ourselves, because they're electing to handle it mostly on their own, mostly because they want to save fees. And then we kind of sit back, and if they need us, they reach out. So it can be catered to how comfortable someone is handling it mostly on their own, or how much involvement someone would like our firm or any firm to have.
Thank you. That's helpful.
Okay.
Do certain people have to be witnesses for like this? I actually have my advance directive from the doctor's office, and I've been procrastinating filling it out, but do certain people have to be witnesses, like a notary, or should I have them witness it at like the doctor's office?
So on the healthcare proxy, and which state are you? I didn't see.
I'm in Maine.
You're in Maine. So I can't necessarily speak to how Maine's form is set up, and in our state, you need 2 disinterested witnesses. So people who aren't, named to be agent or
Okay.
backup agent, but you do not need to have it notarized by anyone.
Okay.
With the power of attorney, you usually need it to be notarized, and you also need 2 disinterested witnesses, and the notary can serve as one of the witnesses as well.
Okay.
Yeah, usually. Again, every state's different, so I would strongly advise you, if you're in a state that's not where I practice, to please consult with to please either look at the law or consult with someone that would know. But that's usually the standard for how that works.
And then how does a will work with, so like for my life insurance, my 401k, I have my primary beneficiary, I have my contingent beneficiaries. Do I have to say in my will, please refer to does
No,
one supersede the other?
Your will does not cover your life insurance policy at all, because it passes outside of the estate, because you've got people named on that account. So, yep. Perfect.
And then if no one else has a question, I have one more. Sorry.
No, this is great. This is perfect.
So with leaving belongings, because of course, and if Pam's on the call, she knows my family. We have lots of like family stuff that passes and we have lots of like Avery family heirlooms that go all over the place. But how do I do I have to describe them? I feel like I'm going to be the weirdo that has like Post-its on the back of all my stuff that's like, if I die and you turn this over, here's who I want it to go to.
That's perfectly fine. So the best practice method, as weird as it might be, would be, yes, to specifically list each item in the will as best you can. And if you're willing to put Post-its on items, as
I'd add pictures
like
to
that,
my will if they'll let me. I mean, I'm really controlling.
Usually no pictures, but a specific list in the will is best practice. With that said, our wills also usually include language about how the testator, you, could leave behind a memo to be incorporated as part of the will, where you could dictate, this vase to this person, this painting to my son, or something like that. The memos are not legally binding. So your fiduciary who you name under the will, well, you might state that you wish for them to honor the memo that you've written. They're not legally bound to do that. With that said, if you're naming someone under the will to be in charge of everything and you don't trust them to follow the memo that you've written, you might want to name
maybe find a new fiduciary.
Exactly. But those are options there. The other option is to make gifts during your lifetime. Obviously you don't want to shed all of your items and have a bare house, but if it's possible to part with a couple items here and there, especially as you do get older, that's perfectly fine as well. That's easy. That makes it easy as well.
Okay.
I'm happy to answer any other questions. I do want to circle back because I realize I mentioned estate taxes and then kind of didn't dive back into that. So when I meet with people, one of their biggest concerns they say is, I don't want to pay the death tax. And they say it like that, and they look all serious. And I say, okay. And so let me explain that briefly. The estate tax or death tax is a tax on your total estate assets, including both probate and non-probate assets. So assets that pass outside of your will or outside of your probate estate would be included in that. With that said, the threshold before you pay any estate tax is extremely high. At the federal level, for one person, it's just over $12 million. And if you're married, you and your spouse can share that. And so it's actually, for spouses, $24 million. At the New York State level, it's a little lower at just over $6 million. So the only time that I ever see someone with a tax issue where there might have to pay some estate tax or death tax is when they have over $6 million. It's not often, but it is possible if someone has a large life insurance policy or something like that. But with that said, like 99% of the people that I work with don't have an estate tax issue. And again, at the federal level, it's even higher. And some states don't have a separate state tax on that. It's just the federal. I think Florida doesn't have a state estate tax. Montana doesn't. I'm not familiar with many others, but I'm sure there's tons. So always something to keep in mind. If you are someone that might have an estate tax problem, meaning you have either at the state level here over $6 million or at the federal level over 12 million, definitely consult with an estate tax planner and with some sort of estate tax lawyer, because there's likely options that you have, whether making a gift to a not for making a gift to something like Wells or another college or another NFP to essentially lessen your tax burden or totally not have a tax burden. With that said, there are certain people that are very comfortable paying that tax, and they think it's their duty to pay that tax. Anything above that threshold, so again, at the federal level, anything above $12 million is taxed at 40%. So it's something that most people like to avoid if they can. So that was my little dovetail back into taxes. The other
Is that
thing,
the same as an inheritance tax? Like
yes,
if I leave my house, somebody inherits my house, is that sort of considered part of the estate taxes
So-
or total assets?
if someone inherits your house, they are not subject to any inheritance tax. It's not a tax that's paid by the person who inherits. It's a tax that's paid from the estate before it pays out assets to people that benefit.
Okay.
Brad, a question on those estate taxes. And this might be pretty esoteric because the limits are so high, but I also understand the limits have changed over time and they may come back down, or
Yes.
who knows, but just to cover it. Does counting towards that limit, whatever that number is in whatever state you're in, federal or state or whatever, do you include those things that pass directly without going through the estate directly to people payable on death, for example, or
Yes.
no?
Yes, so it's weird because there's two terms to use. So in the tax world, when you talk about the estate, it includes both probate and non-probate assets. In the court world, when we talk about the estate, we're only talking about assets that are under the court's control, so only probate assets at that point. But yes, for that tax, for like I said, shifting gears back towards tax, the estate covers, that tax it applies to both probate and non-probate assets.
That's pretty significant, actually.
Yes.
Does it, here's then a follow-up question. For tax purposes, does it include part of the estate that I'm willing goes to Wells College?
no. So if you were to leave money to Wells or any other entity like that, that reduces your estate tax burden. So that essentially reduces your total estate at that point. And that's why, like I said, I didn't want to dive into the major complex planning, but there's CRUTs, charitable remainder, unitrust, there's crits, there's like a whole bunch of different specific planning purposes for those types of issues that I'm very fortunate in that most of the people I work with don't have to go to that extreme. But there's a lot of options, you know, when we get to the higher end side of things to reduce that burden, either by making a gift to, you know, an entity like Wells or some other NFP, or, you know, other options at that.
Well, speaking of giving money to Wells,
Good
not this,
segue, Randy.
this is not a commercial, but serious question actually. Larry's pretty happy. As far as let's say I'm not worried about estate taxes. We're not talking that much money, but let's say I do want to leave in my will some amount of money to Wells. What do you recommend as far as the mechanics of that? Should I let the college know, or whatever the nonprofit is, beforehand that this is coming, so they know to receive it, or will the lawyers just take care of it? Don't worry about it. Yeah. Do you have any recommendations?
Right. So I guess, you know, for starters, you'd want to think about, am I leaving a specific amount, or am I leaving a percentage of my estate to Wells? So that would be the first thing to keep in mind. I certainly can't speak for what Wells likes in terms of whether they like to know a specific dollar amount or whether they're fine with like a rough percentage. But that would be something to keep in mind. If it's just a specific amount, there's less involvement from outside forces. If there's a percentage, at least in this state, the state gets involved to ensure that that money passes, you know, as much money of that percentage passes out to the college or to whatever entity you're leaving money to as possible. So that sometimes will take longer. But with that said, in terms of notifying the entity that you're leaving money to, it's really up to the testator. Sometimes our firm will reach out if we've never had someone leave money to a specific place before, just to see if there's any language that they like us to include in the wills, or if there's anything that we need to know about, you know, who the point person is there. But you don't necessarily need to give notice at the time that you're forming your will, because once you pass away, you're required to give notice at that point to the entity, to the college, to whatever, you know, place is being named, that, hey, there was this, you know, this gift was made in this person's will for this amount of money. Here's a copy of the will so that you can see it. And then it goes on from there. It's always, with that said, it's always a good idea, and not to step on Pam's toes, but I'm sure that Wells has a way to acknowledge, as most colleges do, Wells has a way to acknowledge people in a special way if they're willing, you know, if they go that route and make a specific gift in their will to the college. So I think for college planning purposes, I'm sure they would like to know, but there's no law that says you have to notify them in advance.
Thank you. That's helpful. Yeah.
And we don't need to have contact with an attorney in New York State if we're giving from an estate in another state.
No, because the college has a lawyer that they will use in case that, you know, usually they can handle it. I don't think they always have their lawyer get involved. I can't speak to that. Certainly Pam or Larry, tell me if I'm wrong. But if there's a more complex estate and there might be some concern that maybe the money wasn't handled in the best way and that the college should be getting more than what they're slated to get, you know, based on how the assets of the estate were handled and what the fees charged by the law firm were and all that stuff, then, you know, they might contest that. But usually you don't have to have any involvement with an attorney in the state where the college or entity is located if you're living somewhere else, as a rule.
Well, I don't mean to monopolize it, but since somebody else is asking, one last question from me. Then I promise to stop bothering you. But what's the one biggest mistake you see people make? Obviously, not having a will is probably pretty bad. But say that you've got a will. What do you think's the one piece of advice you give people to a problem to avoid?
That's a good question. Probably for starters, I would say avoid naming multiple fiduciaries to act at the same time. That can just lead to fighting. I've got one estate right now where it's two sisters, and they're the only ones, and they're both in charge of the estate, and naturally they don't get along. I'm acting as attorney for one of them. The other one hired her own attorney. The only asset is the house. One of them lives there, one of them doesn't. So obviously the one that lives there, doesn't want to move out anytime soon. And it's just miserable. So that's one of my usual go-tos, is just try to pick one person. If you have to name two and there's like 3 or 4 kids, okay, but make sure it's people that will be able to get along with each other. So that would be my one of my biggest ones. My other one, I guess, would just be to know to know how your assets are titled, because you'll see people that, I want to give $10,000 to my friend and $10,000 to my niece and all this money, but then there's actually not enough money in the probate estate to cover all those gifts in the will. So then you have to prorate them, and it's just it's not a fun time. I mean, I don't mind it because we bill for all of it, but it's less money that ends up passing out to the people who are supposed to get it. And part of that, I would say, if from what I've seen, is, if we get a will from someone else that a different law firm did, it becomes clear that they might not have they might not have gotten the full background from the person at the time that they made their will in terms of what their assets were, or they made significant changes to how their assets were titled after they did their will and they never updated it. Because obviously, if most of your assets are, passing through joint accounts to someone else upon your death, your will doesn't control those. And if you're leaving over $100,000 in gifts to someone, but you only have $40,000 in your probate estate, we're in for a problem. So that would be number 2, I would say. I'm dealing with that right now too, and it's just we get all sorts here. So, but that would be my second thing. To actually jump off of that real quick. I mentioned how I think everyone should have a power of attorney, healthcare proxy, and will. I think we've really hit the nail thing, or the will thing home. With the healthcare proxy and POA, the main issue there is if something were to happen to you and you're no longer able to make those choices for yourself, there's people in place. If you don't have a healthcare proxy and POA and you're in an awful car accident, you've lost your ability to speak, or you can't walk anymore, you're confined to, either using some sort of scooter or something like that, or you can't, again, you can't speak, or you don't have the mental cognitive ability to make your own choices, and you don't have one of those, you don't have the power of attorney and healthcare proxy in place, you're looking at a very expensive Supreme Court process, at least in this state again, to have someone appointed as your conservator or whatever other term you want to use to be able to then make those choices for you. And that's a very costly proceeding. I usually see it run at least $10,000. So for a fraction of the cost, you can have something in place to cover yourself in the event something were to happen to you, where you're still alive, but not able to perform the normal functions that you were able to do before that specific thing happened to you. And so that's really the biggest thing. If anything, get yourself a healthcare proxy and a POA as soon as possible. And I always tell parents, as soon as your kids turn 18, your kids are going off to college, those types of things, have them come in. We can do a basic one. You always want something in place. I think many of you, I think it made the news, a certain pop star that had, someone acting on her behalf for way longer than than he should have been. I think those stories really give, this type of law and this type of the type of work that we do here a bad name. But with that said, all that could have been avoided had she had other things in place. So.
Brad, Cindy asked a few questions in the comments.
Okay.
If you move to another state, should you have a new will done, or does the will remain in effect? And then there's a second question, but I'll wait.
Okay, to that first question, as long as the will was validly signed and pursuant to the laws of the state where you signed it, it will be considered valid in the state that you've moved to. But at the same time, if you're going to be somewhere else for a long period of time, it doesn't hurt to update it. But usually if you have a will that was done somewhere else, as long as it was validly signed where you signed it, it will be still valid, and you shouldn't run into any issues in the state that you've moved to. I have a will right now that was done in Maryland, and it's been filed here. We haven't had any issues, and their forms look a little different, in terms of how they have things set up, but it's basically the same thing.
Okay. And then she also asked, are healthcare proxies and POAs state dependent?
Every state will usually have their own form. So yes, at least in this state, again, the power of attorney comes out of New York general obligations law, I want to say. So it literally references a specific state law in that form. So definitely, if you're moving to a different state, you should have a new power of attorney in healthcare, and at least a new POA. Healthcare proxy, it's a little more informal in that, like I said, you do them at the hospital and those types of things, but usually always a good idea, especially if you're moving, because your contact information will change. And so it's usually always a good idea to update those forms at that time.
Do you have any comments or questions or like advice? I know you can't really give legal advice, but for people who, should you have like a binder of all of your passwords and things like that? That's kind of what I did this year when I had some healthcare issues, and I just like went through and was like, okay, here are all the things in case I can't act.
Absolutely. And that's always something that we actually ask people on our worksheet that we send out. We say, do you have a list of your passwords? Who knows your passwords? Always a good idea to, I don't necessarily know if you need to have like a list written out, but have at least talk with someone, make sure they know, your basic accounts, or, tell them where that list is, so that they can reference it in case something happens to you. I know on certain things, like I think you can do it on Facebook, you can name someone to like be the administrator of the account in the event something were to happen to you, or in the event you were to pass away. So you have options like that as well. I know it's been a big thing with Bitcoin and other trying to think what the term is for them, other types of payments besides
cryptocurrency.
Yes, cryptocurrency, that's it. Because I think with Bitcoin, there's only one password, and you have like so many tries that you can use before your account's just wiped and you lose all that money. So definitely a good idea if anyone has any Bitcoin or other accounts like that, to definitely make sure someone else knows that password, or have it written down and make sure it's right, spelled correctly, so that you don't lose all of those assets. But yeah, always a good idea, if you have something written out like that. I personally have a spreadsheet on my laptop that my partner knows the password to, were something to happen to me, because it's, you can't just open it. You have to know a certain password to even get access to that spreadsheet. But once she were to gain access, she would see all my accounts, the login information, all that stuff, so that she could, handle things if necessary. So always a good idea. Some people tell me they have it on their fridge, or, it's on my desk, and I'm like, that's great. So if someone broke into your home, it's all right there for them. So you got to be somewhat smart about it, but definitely a good idea. Thanks, Rachel.
Brad, how about your pets and other non-human friends?
Yes.
Is a will a proper place to make arrangements for their care after you're gone?
You can certainly do that. Again, it would be under the tangible personal items section. Some things, what I see, I would say is the most common is that if both, again, if it's two spouses, if both of them pass away, they make a gift of their pet to someone, usually with a specific cash value as well to be used to take care of the pet or something like that. If you're really bougie, you set up a pet, you set up like a separate pet trust for the pet, and the pet is the beneficiary of that trust. And it's this whole separate, it's a very niche field of law. That's for the really, really wealthy people that think that their pets are going to live forever and they can clone them and all that stuff. So usually it's fine to do it in your will. That's the most common.
Anybody else?
All right, anybody else have any questions for Brad?
And this is all, like I said, this is my contact information. If you didn't feel comfortable asking something today or something pops up that you thought of later, feel free to reach out. I usually can, get back to an email within a day or two. If you call me, that usually works too. I'm usually at my desk. I don't venture that far that often, especially these days. I'm very busy, but always willing to chat with Wells alums or someone that you might know, anything like that. I forgot to include a link. If you don't live in this state, obviously, I don't know a lot of attorneys outside of where the state that I live in. But there's a website, I believe it's called the Elder Law Association, or it's like the ELASY or something like that. I'll see if I can have Rachel share that link somewhere. But I always recommend people check that website if they're looking for attorneys in their area. Don't be fooled. Don't be concerned by that name. Any attorney that does, that kind of law will be able to do good estate planning documents for you as well. And I usually find, I don't want to paint with too big of a brush here, but I usually find that they're a little nicer and a little more down to earth than some of the high profile estate planning attorneys that you might see downstate in the city or something like that. So I wish I could remember the website off the top of my head. It's the Elder Law Association of, again, I'm blanking, so I do apologize there. But if you search something like that, you should be able to find that website pretty easily.
Brad, is it
Yes.
the National Academy of Elder Law Attorneys?
That's it.
Okay,
Thank
and
you,
they're in
Brad.
Virginia.
Thank you.
Great,
Perfect.
thank you.
Yep.
Yeah,
it's
and NAELA.
That's what it is. NAELA. Yep.
In
That's
Tyson's
always
Corner,
a good
Virginia.
resource.
Yeah, Google's a wonderful thing.
Well, if anybody else has any questions, feel free to reach out to Brad or the alum office. I dropped the email in the chat there, alumoffice@wells.edu. And Brad, thank you so much for sharing your knowledge. And
Thank you.
it's
Thanks.
really great. It's a really
Thanks
great way
for
to wrap
listening.
up.
Sometimes I feel like, I don't know, I feel like a nerd because I love this kind of stuff, and I know most people they hate talking about it. So I hope no one was bored or no one was lost. Please reach out if someone has any concerns.
Three of us left here.
Well, as someone who had worked on the other side of it in healthcare and had families just going to war with each other, right smack in the, hovering over someone's deathbed. You really do need to do this no matter how young you are and no matter what you think you own or don't own.
For sure.
Yeah, I work for a life insurance company and was really embarrassed that I don't actually have my life in order, and I see the drama unfold daily. So I just want to make sure I'm getting things in order. So thank you.
Absolutely. No,
Right.
I totally understand. I mean, you know, for a couple of years after I finished school and I was working at, you know, firms and stuff, I still didn't have my affairs in order. And I finally was like, what is wrong with me? Like I
Yeah.
spend all day telling people, hey, you should do these things. I was like, why aren't I doing this? And of course, as you get older, you know, you have more things and you have a house and you have kids, and then you really want to sit down and start focusing on that. So absolutely. Well, I thank everyone again. It was so nice to see everyone, faces I haven't seen in a while. Like I said, please don't hesitate to reach out. If there's any questions, concerns, follow up, I'm here.
Yes, thank you so much. I really appreciate it. And we will continue this programming in September. So if you're interested in being part of Learning by the Lake, send us an email at Alum Office and we can see if anything fits into the schedule. We'll start on the second Wednesday in September. And these are available on the college's YouTube page. So make sure you go check out the other ones from this year. We have about 600 people either attend or view on YouTube our Learning by the Lake series this year. So yeah, thank you so much. Everybody have a great night and we'll get that recording up in the next few days. Thanks, Brad.
Thanks,
Thanks,
Rachel.
everyone.
Take care.
Take care.
I've